One of the many executive orders issued by the Trump administration recently calls on federal judges to demand that plaintiffs put down money when defending lawsuits against them that they can get back if they win the case. This is a federal procedure that is in the legal toolbox for them, just now getting more emphasis as the amount of those who have brought suit against agency actions has spiked recently. To get some perspective, I spoke to Sam Finnerty, who is a partner at the law firm PilieroMazza.
It's certainly a rule that's been on the books. It's got a long history. It goes back, I think over 100 years. Originally, when the rule was drafted, there was discretion with the courts whether or not to require the bond. And it has since become a mandatory requirement. However, since, the 1960s or so, courts have sort of interpreted it to say, yes, this rule exists. However, using our judicial discretion, we can take the requirement away if there's public interest at issue, if there would be public harm if we impose this strict bond requirement. And so that's the way it's been, sort of historically interpreted since then. If public interest groups or nonprofits are bringing cases that have particular high stakes issues involved with them, constitutional rights issues, environmental damage, that issues, things of that nature. And so, the administration here seems to be reacting to a couple of things. I mean, it's being framed as necessary in this executive order for a number of different reasons. The first of which is that there's this growing concern that the courts have become politicized and partisan, and there's a perception that there's interest groups out there that are perhaps forum shopping, which essentially just means they're looking for a particular district court that might be favorable to their case, particular judge that, perhaps has ideological political leanings that might be viewing their type of cause more favorably and more likely to issue an injunction, or in some of the cases that have taken place this year, a nationwide injunction, which is what, this administrative action seems to be responding to. There's obviously been, a couple of highly politicized cases the last couple of months where, in response to some of these executive orders that have been issued, which have been rather sweeping, there have been groups that have gone into court and have gotten preliminary injunctions, have gotten temporary restraining orders. There's been restraining order requiring USAID to pay some funds that have been frozen. There has been executive order stopping the Department of Treasury from getting access to certain documents. And so, the administration seems to be responding to that, trying to stave off perhaps frivolous lawsuits that are being filed and stop this forum shopping, and also with the perception that they want to stop taxpayers ultimately from bearing the brunt of the costs if these injunctions are later found to be issued improperly, and the government therefore has been delayed in implementing its policies.
Got it. All right. So is this attainable, actually? Because not every judge is going to agree with this, right?
I mean, it kind of remains to be seen. The executive order requires that agencies now specifically fight for this bonding requirement in court when an injunction is being sought, whereas in the past, that hasn't been the case as much. So it really kind of remains to be seen how this gets enforced and what the rules are going to be for it, because it raises a lot of questions, particularly, what are the policies going to be for determining the amounts of these bonds and what the process is for that? Because some of these cases, it's hard to quantify what the damages are going to be, when you're affecting someone's constitutional rights, for example.
Yeah, is this in the playbook for a DOJ attorney or an attorney representing a particular federal agency? Because, as you mentioned, most of these activist groups know what they're doing and they know when they're going to have a favorable court. Is this really going to make any difference if the judge that they're presenting to does feel in favor of the group bringing the case? Why would they issue the bond requirement if they are already leaning towards the group that is bringing the case in the first place?
Yeah, so I think you're asking, why would they require the bond if they're already leaning towards the cause of the group that's bringing the action? I mean, it creates a separation of powers issue, I suppose. Here, you've got the executive branch and the judiciary that are sort of jockeying for a position here, and who ultimately gets to enforce the law. The executive would argue that that's their job, and the judiciary can stop them from doing it if there's a case that's litigated on the merits that ultimately defines that some executive order they've issued or policy that they've outlined is illegal. And so I think, what you have now is another executive order saying, hey, courts, agencies specifically, you got to require this. You got to fight for this. It's in the rules already. There's no there's arguably no discretion in the rule, at least as it's written. It says that you can only issue these injunctions if there's a bond posted. So what this is setting things up for is ultimately a fight in the future. If there's already courts that are inclined to not require the bond, is this executive order going to change things? I just don't know. What it could set things up for is an appeal. Certainly, if there's not a bond that's required by a certain court and an injunction is then issued, the government could then seek appeal and they perhaps get that appeal in front of a court that would be more favorable to them on this issue. And, then that court that required the bond gets overturned on appeal. And that's something perhaps they want to avoid. So maybe with this, courts now will be more inclined to require that bond. But again, the judiciary has been of the viewpoint that they have the discretion, and that when public interest requires it, they have the discretion whether or not to require this. If you have an indigent client or plaintiffs that really don't have the ability, bonding requirements can be significant. If the damages in some of these cases can be significant, the bond that they have to put up is significant. So it creates a equal access to justice issue as well. Some of these groups are unable to get in front of the court. That's why the courts, frankly, have waived this and not imposed this requirement in certain cases, recognizing that there are serious fundamental rights at issue here that they want to take seriously, and that if you don't issue the injunction, perhaps you can't put the toothpaste back in the tube once the damages are done. So that's sort of the reason for the injunction in the first place.
We're speaking with Sam Finnerty. He is a partner at PilieroMazza. All right, and I wanted to get into the actual bonds themselves. Just how significant are they when a plaintiff is bringing a case? Obviously, the way it works is the judge says, I haven't decided yet, but in the meantime, you got to put up some money just in case I decide in favor of the federal agency that you're suing. Yet you talked about the significant costs. I mean, what are we talking about here, and how do they come up with the idea of that cost?
Yeah, it's usually calculated by the court itself, and they're going to take into consideration, the potential damages at issue, perhaps the financial condition of the party that's moving for the injunction. And historically, they've taken into account, public interest issues and deciding whether or not to waive those bonding requirements. The bond amount itself is intended to be equal to the amount of potential damages, in this case to the government, if the injunction is proven to be wrongly issued. Those damages, however, can be difficult to quantify. If it's in certain cases here, the government, trying to issue executive orders, terminating broadly thousands of government contracts across the board, the damages to the movement would obviously be the value of that contract. And on the flip side, the damages to the government, if it's determined that the government had the right to issue those contract terminations, well, then I suppose in some respect, the damage to the government would be whatever it costs them to not be able to terminate those contracts. So, in certain cases, the government could make a case that, damages might be in the millions, which means that for some of these bonds, that you have to put up to get that value of a bond, you're going to have to put up tens of thousands, if not millions of dollars.
Does the government have, I guess, a point here, though? They're attempting to cut funds that the government is spending, and they're attempting to make several big moves that we've all been hearing about and I've been reporting on. Do they have a point here in saying, look, we're trying to take action, and this is really going to gum things up if every time we take we make a move, we have to deal with several thousands of folks coming to us for litigation against said move? Perhaps maybe a bigger voice needs to interject here, maybe to kind of set a precedent so that there is a standard to follow. Would that help things out?
Yeah, to your point, proponents of this and the administration, there's, it's a big, complicated issue. However, there are certainly arguments on both sides of this. Proponents would say that, hey, this rule already requires this. We're just asking that courts enforce what's already on the books. And in this case, this is, we've seen just this year, there have been these sort of nationwide injunctions where a single district judge has blocked executive action nationwide, which assuming that that executive action was legal at the end of the day, the delay there in adjudicating that case on the merits to get to that point of determining that what the agency or what the federal government and executive branch wanted to do in the first place was legal. I mean, there's a significant cost to that being delayed if these courts are issuing these nationwide injunctions. So the argument would be that we want plaintiffs to have some skin in the game if they're going to be raising these lawsuits.